The order of the Justices of the Montana Supreme Court.
We take the opportunity as we begin to thank the State Bar of Montana and the folks at the University of Montana Law School for their assistance in first inviting us and then assisting, helping to put this together, as well as the introduction. You may notice that we have we're flying in a missing man formation. This morning, Justice Shea, not available to be here due to a family wedding, but he will be participating in the case and will review the recordings of the conference. Counsel, ready to, by way of introduction, this is cause number OP 220023, Charles Daniel Smith versus Charter Communications. Mr. Holmes.
Good morning, Justices of the Montana Supreme Court. My name is Eric Holm. I'm an attorney in Billings, Montana, and I represent the plaintiff appellant Charles Daniel Smith, who goes by Dan. May it please the court. The question here is whether we will expand the reach of the 1999 anti-blacklisting statutes amendments beyond their clear words and intent. And what's at stake here for us is whether employers in a wrongful discharge case will be allowed to alter their reasons for termination set forth in a standard discharge letter months or years later in litigation. The Galbraith rule should be upheld because the 99 amendments do not apply to the WDEA. And the rule has been broadly applied beyond the confines of a specific request for a service letter under that anti-blacklisting statute. The 99 amendments were to the anti-blacklisting statute, which now on its face only applies if a service letter is requested and given under that specific statute. The Galbraith rule, meanwhile, had logically and reasonably been applied pre-1999 to WDEA cases not involving a request for a service letter, like the facts in this case. They were also applied to a claim for unemployment benefits, to a claim for UTPA, to an unemployment claim, and others. So the amendments in 99 should not affect the Galbraith rule that had previously grown beyond the blacklisting context and the service letter context. The statutory language after these amendments is very clear. It only applies where there's a request for a service letter and where there is a service letter. The language quote says, upon demand by the discharged employee, the employer must submit a quote response or be barred from giving any type of reference call later. It then says, quote, a response to the demand can be later modified and does not limit the employer from presenting a full defense. And so based on the clear statutory language, even after the 99 amendments, this ability by an employer to modify the reasons for discharge does not apply outside of those specific circumstances. In our case, Dan Smith did not plead a blacklisting claim. He did not request a service letter. He did not receive a service letter. He had a meeting with his supervisors, which happens every day in the state of Montana, and they gave him a written termination letter that explained and identified two specific reasons for discharge. So while these 99 amendments would allow an employer to alter any type of reason in a service letter, here there was no service letter. There was only a voluntary discharge letter. As such, the current version of the statute on its face does not apply to the case. The amendments do not allow charter in this case to modify its discharge letter and change the reasons why it fired Dan Smith. Even if we look to the legislative history, it's clear what the purpose of these 99 amendments were. The fundamental purpose was to protect an employer from blacklisting lawsuits, not from wrongful discharge lawsuits. The purpose was allow an employer to speak more freely if they receive a reference call from another potential employer. That legislative history shows that employers back in '99 were concerned over blacklisting lawsuits. They wanted to be able to have open conversations with other potential employers who called them asking about a particular employee. Almost every comment at the committee hearings was completely limited to attempting to protect employers from being sued for blacklisting. Now, with that said, it is true that a concern over the WDEA was mentioned during those proceedings. In fact, language was even proposed to these 99 amendments that would have specifically word for word applied them to the Wrongful Discharge from Employment Act. That language was removed. It was never adopted.
Language come from the governor's amendments.
That's some of the language that I'm speaking of, yes. Governor Roscoe wrote a letter during that legislative process, and he himself raised concerns about the Wrongful Discharge Act and referred to recent cases. The most important thing, take-home message from that, is that that language was never entered actually into the bill. It was never passed as law. It never reached the amendment. And so despite there being some concern over applying this situation to the Wrongful Discharge Act, the legislature considered that and never adopted that approach. And so what we're left with are the 1999 amendments as they're written, with no reference to the WDEA, and instead only a self-referential statutory scheme under the anti-blacklisting statute that does not go outside of that to the Wrongful Discharge Act. What else is important is that there was no intent to abrogate the common law by these 99 amendments. If we could.
Counsel, that's clear that the cases were referenced in terms of the legislative discussion.
There was mention of recent cases, absolutely. One thing that the legislature has an option to do is when passing an amendment, create specific language stating a clear intent to abrogate that common law. And they did so most recently to section 27.1308, which regards subrogation rights.
You don't think that the three cases that were mentioned was an intent by the legislature to abrogate those cases?
No, because those cases were mentioned during the course of the legislative hearing process. And so there were lots of topics and concerns raised and discussed during those. When it came time to finalize the language of the bill, the legislature chose not to include a separate section that said something along the lines of the purpose of this section is to abrogate the common law, court decisions, and all prior statutes applicable, which is what the legislature did to 27.1308. And another principle we need to keep in mind that was reiterated recently in the State v. Wolf case, which is 2020 MT 24. This court stated, quote, "We have long embraced a presumption that if the legislature disagreed with our historical interpretation of a statute, it would have exercised its prerogative to revise the statute to override our interpretation and affect the proper legislative intent. And so when these 1999 anti-blacklisting statutes were amended, there was no clear legislative intent to abrogate. And we have to look to that principle in Wolf, where the court stated that in circumstances like this, where the legislature had chosen to not act, generally, this is a quote, generally, we will not disturb a long-standing interpretation of a Montana statute. And so we have to keep in mind the timeline here is that Swanson was issued in the late 1970s. It was applied in Galbraith to the Wrongful Discharge Act in 95, and then there were 3 1998 cases that reasserted it. And so the legislature certainly could have made a specific reference to abrogating the common law. They certainly could have made a clear intent that they disagreed with how the Montana Supreme Court had been interpreting and continuing the Galbraith rule, and they didn't. And so under Wolf, we would have to abide by that precedent.
So I have a question, more to the evidence in the case or the question from the Ninth Circuit. I have a little bit of trouble understanding the rationale behind rejecting the district court's reasoning. If you could address that.
The district court in this case?
Yes.
Yes. Well, it's interesting because, so this was in the U.S. District Court out of Billings, and Magistrate Judge Cavan ruled on the first decision for summary judgment and denied summary judgment. And so Judge Cavan stated that the Galbraith rule was binding in the state of Montana, and that Charter was bound by the reasons set forth in its termination letter, and there were material fact questions that would preclude summary judgment. Objections were submitted, and that case then went to Article III Judge Waters, who looked at it and agreed that Galbraith is the rule in the state of Montana. The only difference she had with Judge Cavan was that she believed that some of these outside reasons like low morale and this quarterly site visit reason were incorporated into the discharge letter. And so that's why she granted summary judgment, is because she felt that those extraneous reasons were encapsulated within the discharge letter, but she still felt that she was bound by the Galbraith rule. So that decision, the plaintiff appellant appealed that to the Ninth Circuit. So really both judges in this case have agreed with Mr. Smith here that the Galbraith rule is still the binding law in the state of Montana. The Ninth Circuit sort of took this question up on its own and wanted the Montana Supreme Court.
So why you think the quarter site visit isn't part and parcel of the 50%? You see what I'm getting at?
Yes, yep. And so that really dives deep into the facts of this case, because in the year of 2017, Dan Smith worked for Charter during Q1 and during Q2. He admittedly did not travel to all of his regional sites in each of those quarters. Charter disciplined him in the second quarter, not for that, but for some other technical aspects of his job with relation to providing internet services. His supervisor testified under oath that those reasons that he was written up for in the second quarter were resolved. He had no further disciplinary issues. He was not terminated for those reasons. And so Charter certainly had the opportunity to write up Mr. Smith for not visiting quarterly in the first quarter and second quarter. They chose not to, which under several cases, the one I'm thinking of is it's a federal district court case out of Billings, Rose Kelly. It states that if an employee does engage in some behavior that could potentially violate a policy, but the employer sort of lets it slide and maybe even gives a good review, then that cannot be considered as good cause. And so here Charter did not write him up for those things. During Q3 and over half of Q4, Dan Smith was on a mission trip to South America. He was on approved leave, and so there couldn't have been any sort of travel reason why he could have been terminated during Q3 or the first part of Q4. We get to the end of Q4 and Dan Smith is fired for two extremely specific reasons. That termination letter is in the record. I don't have it in front of me. The only one that's at issue on appeal specifically stated that during the month of December 2017, not an entire quarter, just 1 month in December 2017, he did not travel 50% of his time without explaining to a supervisor why he could not do so.
Judge Waters said he didn't travel 25% a quarter to even meet the quarterly requirement. I mean, that's not disputed, is it?
Well, so it's not a 25% travel. What the policy is that he had to visit all of his sites once per quarter, per calendar quarter. And so there was never a 25% requirement. What Charter has always argued in this case is that there was a policy of Charter requiring Dan Smith to travel 50% of his time, regardless of where he visited and that sort of thing, which we've established through a mountain of evidence that was not a policy during December of 2017. And so now they're trying to bring in this quarterly travel requirement, which was a requirement. It was a requirement that he did not meet in Q1 and Q2. But our arguments are twofold. One, that was not the reason they terminated him. It is not in the termination letter, which was very specific. December 2017, 50% of the travel time. And the second reason is at the time that the first quarter and the second quarter elapsed and he did not travel to those sites, it was accepted by Charter as meeting the expectations of his job because he was never written up for that.
My microphone isn't working, but the Ninth Circuit cited Galbraith for the principle that an employer may not introduce evidence unrelated to the reasons given for the discharge. And would the question be whether failure to comply with the policy, the travel policy, was related to the reasons given in the letter, whether it was 50% or needing the site visits? It's not similar to McConkey or I mean to like the Bean case where there was unrelated misconduct. And that's what the Ninth Circuit tried to distinguish. So I'm having trouble with why it isn't related.
That's a great question. I would start off by saying that the term related is not what the standard is. In Galbraith and following cases, it is reasons that were not itemized in the termination letter, not contained within the termination letter. And so if we used the standard of whether these extraneous reasons are in any way somehow related to the reasons in the termination letter, that's not what the Galbraith and McConkey rule is. And
in its rationale for the certified question, it used the phrasing of whether it's related or not and concluded that it was not related to the notice that he was given. And the rationale used by the Ninth Circuit to formulate the certified question includes the strictest application of the Galbraith rule that we've ever seen in the state of Montana. Never have we construed it that strictly. It compared it to, it said this is a Bean case. It's not a Bean case, with all due respect, where the employer tried to bring in information about a totally different kind of misconduct or employee behavior than what was placed in the notice. Here we have a notice that says you're being discharged because you violated the travel policy. Well, it said the 50% travel policy instead of the quarterly travel policy. And the U.S. District Court said, you know, that's close enough. We have cases where you can bring in additional information from the employer to supplement the notice that's close enough. The Ninth Circuit said, we don't think it's close enough. So if the Ninth Circuit is wrong about the law of Montana that goes into the formation of the question, where would that leave us?
Well, I mean, I think even under that standard that the Ninth Circuit is using, we have to place some type of responsibility on judgment decisions of employers. In particular, I mean, the facts of this case are the only facts that are before the court at this time. This is an employer, this is a Fortune 100 company who has some of the best HR representatives and lawyers that are out there. When they use their business judgment and terminate a long-time, high-paid employee for a very specific policy reason, for one particular month in the winter of 2017, that reason is not related, if we use that standard, is not related to not meeting quarterly visits, traveling to all of your sites once per quarter, not determining how long you're actually there or how many folks you speak to, but just traveling, showing up. I mean, if we want to get down into the facts of that, I think there's clearly a factual dispute as to whether those things even are related. And so that's why we're here. This was a summary judgment decision. So I think we're sort of still in the same boat of, we have to look at the four corners of the discharge letter and say, okay, what is the purported good cause for this termination? Because that's the standard we're under on the WDEA is what's the reason that he was fired? The best evidence of that reason is a timely, contemporaneous termination letter that is very specific and attempts to use exact policy language.
Your position would be, if the termination letter had not said you're being discharged because you violated the 50% travel policy, but had only said you're being terminated because you violated the travel policy, we wouldn't be here, right?
Those facts are not before the court. That's correct. Yes. And what the decision would be in that case would be saved for another day. Absolutely. What the court was doing in Galbraith was essentially interpreting the WDEA. And I think I touched on this just recently. The statute itself does not define what grounds are or what a legitimate business reason is. The point is, we have to find out what the grounds are and what the reason is. And so Galbraith, what it was doing is making a decision on how we can interpret exactly that. What was the purported reason for the termination? And so I think it's a very sound rule. It was well applied as an evidentiary interpretation to apply, to interpret the terms of the WDEA and to apply it to a situation like we have here, where there's been no request for a service letter. There's been no service letter. This is a standard termination letter. And so it is our request that the Galbraith rule be upheld as good law. And at this time, I would like to have Amicus mention a few things. Thank you very much.
Thank you, Chief. Justin Stolpis here on behalf of the MTLA. As an organization, we have the benefit of looking at this issue purely from a legal standpoint and the question posed by the Ninth Circuit. The question posed by the Ninth Circuit to this court is whether the amendments to the 1999 anti-blacklisting statute did in fact abrogate the termination letter rule, which, if we go through the case law, is based, obviously Swanson references it, but if we look at Galbraith, McConkey, part of the issues there, or the reason is, we're looking at the actual reasons for discharge. Rule 402 of the Montana Rules of Evidence apply in every case, and especially in this context. So we're looking at what actually was the reason. Rule 1 of the Montana Rules of Civil Procedure guarantee each side the just, speedy, and inexpensive determination of every case. Delving into collateral matters, which are not the reason for discharge, don't fall within the auspices of that rule. It's remarkable to myself as part of the organization looking at this issue that the only circumstances in which this dispute will apply, as noted by the Ninth Circuit, is where an employer terminates an individual, writes a voluntary letter stating all of the reasons for that termination, and then in litigation concedes that those are not the actual reasons for termination, those are bogus, and seeks to import new ones. I think we can all agree that it's a good rule, right? We believe it to be a good rule that an employer is bound by those reasons. I hear the concerns with the facts in this case. We have a case in Montana jurisprudence, Jarvanpah, which addresses that issue as far as the basis in bringing in evidence to substantiate the reasons set forth in a termination letter. If there are qualms with the way that the Ninth Circuit may be adjudicating those facts or may be interpreting those facts, I would posit to the court this isn't the proper venue for that. That court, being an independent body, an independent branch of government, has its right to interpret those facts and interpret them. The question for this court is what the law of Montana is, and specifically whether the 1990 statutory amendments to the blacklisting, the anti-blacklisting statute, abrogate that rule that's applied in Montana that I referenced as the voluntary termination letter. Both sides, I've read the, yes, no, please.
Maybe it's not just the Ninth Circuit's interpretation of the facts, which I agree with you, we don't get to weigh in on. But as Justice Rice suggested, the Ninth Circuit's interpretation of the law. How do we deal with that?
Well, the Ninth Circuit has a question that it posed as to whether the blacklisting statute abrogates the termination rule. I think the question is whether how it interprets the breadth of Jarvanpah as to relatedness, if I'm interpreting your questions correctly. And please correct me if I'm not.
What we said in Galbraith was collateral reasons
Right,
are irrelevant under Rule 402.
right.
And so the Ninth Circuit said in this case, it was a collateral reason under that. I mean, they used unrelated to, but
Right,
similar.
but they're saying it's collateral. They're making that factual determination that the quarterly travel requirements aren't related, are collateral to the 50% rule, which, be that as it may, that's their determination to make based on these facts in adjudicating whether genuine issues of material fact exist. That's for them to do. We have a diverse, this case was removed. I assume it was removed. Therefore, Charter chose to have the Ninth Circuit ultimately adjudicate this dispute. However, they may do so on these facts. Both sides, having read the brief, agree that the statute is unambiguous. And as is often the case, in case someone decides otherwise, you bring in legislative history. But both sides agree that the statute is unambiguous, and the organization agrees with that as well. The amendments,
The WDEA.
the amendments to the blacklisting statute, which are at issue in the Ninth Circuit certified question. So the amendments to the blacklisting statute, the unambiguous as agreed by the parties, amendments, and just looking at them, apply solely, so they allow an employer in a blacklisting case where they're sued for blacklisting to bring in collateral reasons to amend their discharge letter that was given in response to a demand. And the response to a demand language is used throughout. In the blacklisting, as I know the court is aware, in a blacklisting context, an individual can request that a letter be provided. If the employer chooses to respond to that, They can, because of the amendments, thereafter amend those reasons and defend the blacklisting case on reasons different than those set forth in the original demanded letter. This is not that context. This context, this rule, the termination rule applies outside of the blacklisting context, applies outside of the context, outside of the circumstances where an individual requests a letter. It applies because this court and our rules guarantee that we're not going to have to litigate collateral matters. And this court has left a wake of jurisprudence indicating that reasons not set forth in a termination letter are collateral.
Let me ask you, counsel, if this case were a blacklisting case, how does the in response to the demand language apply here?
If Smith had requested a letter and been provided a response, and then if Smith had sued Charter for blacklisting under that section of the statute, Charter would be entitled, pursuant to this statute, to amend the responses to its letter and litigate on other grounds.
So let's say they don't request a response or
And if I may, if that issue was presented, which it hasn't yet, if that made it to this court, and if this court determined that separation of powers had not been defied by the legislature in doing that. But anyway, sorry.
what I'm getting at is, does this language preclude, it also precludes blacklisting litigation only if there's a demand letter.
It only allows subsequent modifications if there has been a demand and a response. Is that what you're getting at, Chief? I agree. That's what the legislature wrote. I agree with that interpretation. With that, I will cede the rest of my time to Mr. Holm for the rebuttal. Thank you.
Thank you, Mr. Chief Justice. May it please the court, Josh Kirkpatrick of Littler Mendelson, appearing on behalf of Defendant Charter Communications. The issue certified by the Ninth Circuit presents a really narrow issue, whether the Galbraith rule remains in effect following the 1999 amendments to the blacklisting statute. Smith contends on page 12 of his opening brief that the legislature's legislative history of those amendments supports the conclusion that the amendments are limited to the blacklisting statute. I do not believe that is correct. In fact, the court would need to ignore the only portions of the legislative history on point in order to reach that conclusion. Senator Keating, chair of the Committee on Labor and Employment Relations, described vividly an employer who tried to ease the blow of separation by soft pedaling the reasons for termination, only to be limited in its defense of a discharge claim. Senator Keating also introduced a letter from Anderson Forsyth of Moulton Benningham describing the problem in detail and specifying the very cases that had caused the issue. Governor Roscoe applied his own fix, amending the blacklisting statute to the language that was passed and specifically stating, I believe that a fairer method of addressing the problem would be to retain the existing requirement to furnish a statement of reasons for discharge, but to permit an employer to provide additional evidence of job-related performance if the discharge results in litigation against the employer. Under my proposed amendment, the law would protect the rights of both employees and employers. The Ninth Circuit recognized the importance of this legislative history, stating that it may contain useful guidance. Smith argues that a change to the blacklisting statute didn't amend the WDEA and doesn't change the case law interpreting the WDEA. But that argument misses the fundamental point that the blacklisting statute was the sole basis for the holding in Swanson, which in turn was the sole basis for the holding in Galbraith. If the legislature wanted to fix the problems it had created based on an application of the blacklisting law to the WDEA, of course it amended the blacklisting law. The WDEA doesn't say anything about what evidence is admissible in a WDEA case. That was a creature of Galbraith. As Justice Rice observed in State v. Legg, when interpreting the statutes, this court's, quote, only function is to give effect to the intent of the legislature. I submit that the intent of the legislature could not be clearer. A review of just 8 pages of the legislative history answers the Ninth Circuit's question and brings this case to a close. Respectfully, it's not a closed case, which is why almost every court to actually examine the impact of the 1999 amendments to the blacklisting statute on the Galbraith rule has held that Galbraith was superseded by statute. I'd like to summarize very briefly the factual history of this case, although I think the court mostly has it.
Well, before you do that, let me just ask you, so what do we do with this language response to the demand?
I think we have to recognize that the language in response to the demand being the basis for Swanson and being the basis for Galbraith means that it applies in any case. And that's specifically what the amendment from Governor Roscoe made clear, was that the language can be changed and it applies in any case, not just a case under the blacklisting statute. And that was after a suggestion, by the way, by the commentator from Moulton Benningham, who said, well, we should specifically reference the WDEA in our amendments to the blacklisting statute. Governor Roscoe, recognizing that Bean, one of this court's decisions from 1998 applying the Galbraith rule in the context of an unemployment appeal, also had applied the Galbraith rule there, separate and apart from a WDEA claim. That's why Governor Roscoe's fix made more sense to say they can present a full defense in any case. So it's not just limited to the blacklisting statute. Does that answer your question, Chief Justice?
No. My question is, we don't have a demand.
That's right. We don't have a demand letter here. There was no demand letter in most of these cases. There was no demand letter in Galbraith, or well, there was no request for a request for a service letter.
Yeah.
There was no request for a service letter in McConkey. There was no request for a service letter in Jarvanpah. And nonetheless, the rule of the blacklisting statute was applied. I submit inappropriately. Smith was, as described in the briefing, vice president for charter, vice president of ISP or inside plant. He had sites in 3 states, Montana, Wyoming, and Colorado, with about 50 sites throughout the region. Throughout 2017, his job required him to travel to each of these sites quarterly. In 2018, at the beginning of 2018, that ISP playbook that Mr. Holm mentioned was changed from quarterly site visits to 50% travel. This whole dispute of fact about 50% versus quarterly site visits is frankly a bit of a red herring. If one can imagine, if Mr. Smith had been visiting 50 sites on a quarterly basis, he would have been traveling about 50% of the time. So it's really a distinction without a difference. And Mr. Holman suggested that there was a mountain of evidence suggesting that there was no 50% travel rule in 2017. In fact, all of the witness testimony was that that was announced, but it didn't make it into the ISP playbook. The mountain of evidence upon which Mr. Smith relies is the fact that he didn't get the memo, apparently. He says, I didn't hear that. I wasn't on those calls. He didn't know, but everybody else did.
I just want to make sure. I'm clear.
Sure.
It wasn't your, it wasn't the policy, right? Are you saying, on the one hand, it wasn't the policy of 50%, it wasn't in effect yet, but he should have known it was in effect anyway?
The senior management employees who testified to this issue at deposition said that it was absolutely announced on calls and things like that, but it didn't make its way formally into the ISP playbook until the beginning of 2018.
Okay, so you kind of both ways then, really not part of the ISP playbook, but you should have known and followed it anyway.
Well, it was announced, just like any policy change could be announced verbally. You can imagine, calls with all of the various vice presidents saying, hey, you guys need to be out in the field. This job requires you to travel. You should be out there 50% of the time. And that announced policy change became part of the formal ISP playbook at the beginning of 2018. But regardless, with respect to the quarterly site visit requirement, Smith contends remained in effect throughout 2017. The Ninth Circuit noted that his travel fell far short of that requirement. Smith's expense reports, which were part of the record, indicated that Smith failed to travel at all during Q1 2017. He visited none of his 50 sites during Q1 2017. During the second quarter of 2017, he made one 4-day trip. And in December of 2017, the only site he visited was the Billings site, which is literally across the parking lot from his office. As a result, the Ninth Circuit held the record decisively establishes that Smith failed to meet the specific travel requirement that he visit the sites quarterly. On January 29, 2018, Charter separated Mr. Smith's employment and issued him the termination notice that we've been discussing. He brought a single claim for violation of the WDEA, and the district court granted Charter's motion for summary judgment, finding that the dispute was not material, as we've discussed, because regardless of whether you're looking at a quarterly site visit requirement or a 50% travel requirement, he didn't meet it. And holding under Jarvenpaugh, this relatedness issue. Jarvenpaugh was the case that announced in 1998 that a court could consider reasons that substantiated the reasons given in the discharge letter. That's the language Jarvenpaugh used, was substantiated. And the district court, Judge Waters, found that the failure to travel in Q1 and Q2, coupled with the admitted application of a quarterly site visit requirement, substantiated the fact that 5% travel in December of 2017 was sufficient grounds for termination and provided Charter with good cause for separation.
So counsel, where is there the dispute as a matter of law, or where is there, I guess that's kind of where I'm focused, and the Ninth Circuit's opinion and the certification order, I don't understand that, their reasoning.
I can only tell you, Justice McKinnon, that I think I spent half of my time at the Ninth Circuit talking about the fact that this failure to travel in Q1 and Q2 and the quarterly site visit requirement substantiated the reason given in the discharge letter. I don't agree with that portion of the Ninth Circuit's decision. There was a couple good questions asked about what if we disagree with the Ninth Circuit? What if we think that this failure to travel in Q1 and Q2 actually does substantiate the reasons given in the discharge letter? Under Rule 15, this court obviously is empowered to reformulate a certified question. It could do so in this case by saying, we've reviewed the certified question and the record. We believe that the failure to travel in Q1 and Q2 substantiates the reasons, and under Jarvenpaugh and McConkey, we find that evidence is admissible. That is an option available to this court, I believe. But I submit to you that the right answer is that Galbraith was superseded by statute, and this court should actually address the merits of the Ninth Circuit's decision by answering the certified question and holding that Galbraith no longer remains good law. Again, I think we've walked through a bit of the history of the case law, right? Swanson v. St. John's Lutheran Hospital in 1979. In that case, a CRNA, or certified registered nurse anesthetist, was separated after she refused to take part in a tubal ligation, a sterilization procedure. And there was a personal conscience statute that prevented that separation. She requested a service letter pursuant to the statute, the old version of the statute, and was provided a letter mentioning only her refusal to participate in the surgical procedure. Afterwards, there were the, the hospital asserted that she was an employee of questionable value, truly collateral to the issue of her refusal to participate in the sterilization procedure. And under the old version of the statute, the court said you can't rely on that. That holding was greatly expanded in Galbraith because Bruce Galbraith had not requested a service letter. Yet this court held in Swanson, we concluded that in a wrongful discharge action, the only reason for discharge the district court could consider was the reasons set forth in the discharge letter. Reasons other than the reasons stated in the discharge letter were irrelevant and excluded from evidence. Again, solely reliant on Swanson. Galbraith essentially read the restrictions contained in the blacklisting statute into the WDEA. Justice Weber's dissenting opinion in Galbraith, which was joined by Justice Turnage, cautioned that the blacklisting statute had no application because Galbraith had not requested a service letter. He said, as a result, section 39-801 MCA is not applicable. Obviously, he was in the minority, it was a dissent, but it's perplexing that his cautioning didn't make its way into the majority opinion. There was no explanation of why the rule applied, notwithstanding the fact that Mr. Galbraith had not requested a service letter.
About the rest of that paragraph that you started reading, even though it doesn't reference the dissent directly, it says the court permitted the jury to decide whether the discharge was wrongful based on reasons other than or in addition to the sole reason stated in the letter. Any collateral reasons were irrelevant and therefore inadmissible, and cites Rule 402. So the court sort of backhandedly addressed the dissent by specifically stating collateral reasons are irrelevant.
Well, the problem with that, I think, is that it is creating a blanket rule that if it's not stated in the termination letter, it's irrelevant. It is frankly not the place of this court to create such a sweeping rule. Evidentiary questions are best left to the trial courts because context is important, right? We expect trial judges to make an assessment based on the evidence and the testimony, what is and is not relevant, and creating a broad rule that anything that's not in the termination letter is irrelevant. I mean, someone could literally murder a coworker, and if it's not in the discharge letter, it's not relevant evidence. It seems that rule is far too broad, Justice Baker.
So counsel, but the 1999 amendments to the blacklisting statute, that was, decades ago, and we've been applying Galbraith, and I mean, why hasn't if the legislature wanted Galbraith modified, they could have done so in the WDEA.
They could have. I want to walk through that legislative history in a little bit more detail because I think it's very clear they did intend it to apply to cases like this. And, the fact that the court has been applying it for a long time should not stop the court from correcting the Galbraith rule at this point. There's a great quote. I'm sad that Justice Shea is not here because he had a great quote in
He has a lot.
in ALPS Property and Casual Insurance Company v. McLean and McLean, 392 Mont 236. He said, stare decisis does not require us to perpetuate incorrectly decided precedent. To the contrary, we are obligated to overrule precedent where it appears the construction manifestly is wrong. He includes a citation. It says, insofar as our prior case law incorrectly perpetuated this error, those cases are overruled. And that is exactly the result that should obtain here. Galbraith, and I can explain myself time permitting why I submit that the Galbraith case was wrongly decided at the time, but certainly the 1999 amendments were directly related to it. Again, three cases, Jarvin, Paw, Bean, and McGillen, which I don't know that I've got time to walk through, but those three cases resulted in the amendment to the blacklisting statute. That amendment was threefold. to delete the requirement to provide a full, succinct, and complete statement of reasons, to add a written demand under this part must advise the person who discharged the employee of the possibility that the statements may be used in litigation, and adding a response to the demand may be modified at any time and may not limit a person's ability to present a full defense in any action brought by the discharged employee. Failure to provide a response as required under subsection 1 may not limit a person's ability to present a full defense in any action brought by the discharged employee. Through that amendment, Swanson, the headstone on which all of these cases were built, had been eviscerated. That's precisely what the courts concluded in 3 cases that have actually analyzed this issue: Erdman v. Walmart Stores, Bordelais v. Semi-Tool, and Stevenson v. Philco.
I guess you didn't like McHugh.
I'm sorry?
I guess you didn't like
I
McHugh.
didn't like McHugh, but I understand it, right? I get it. Judge Christensen didn't have the benefit of the legislative history that I'm about to hopefully walk through, and he was following your precedent, as he's obligated to do. But I think the 3 cases that analyzed it closely, again, and it's the fact that this is actually an easy question, I think, is borne out by the fact that those 3 cases got it right, even without the benefit of the legislative history, because the legislative history is so powerful here. Again, given that this court's charge is to give effect to that legislative history, I'd like to do a bit of a close examination of that. Senator Keating, chair of the Committee on Labor and Employment Relations, raised these concerns that the language of the blacklisting statute had been engrafted into WDEA cases. And he sought to draft legislation that could narrow it. On February 16, he addressed the purpose of the amendment in the committee meeting minutes. These are contained in attachment 2 to Smith's opening brief at pages 32 to 33. And with the full knowledge that the court probably is less fond of being read to than my 5-year-old is, and for the benefit of the audience, I would like to read a little bit of this into the record. Senator Keating alleged the last amendment is born out of a situation of if an employer is not comfortable with giving information to his employee regarding firing him and says that his work is sloppy. If that employee files a wrongful discharge suit on that basis, again, a wrongful discharge suit, the sloppy work is the employer's only defense. There may be a host of other reasons which are truthful. Under current law, he is prohibited from using anything else. He can only use the statement given for the reason of firing. This amendment states the employer is not bound to just that statement, clearly intended to apply to wrongful discharge actions. He also referred to Exhibit 2, the letter I mentioned earlier from Moulton, Bellingham, Longo, and Mather, which was contained at pages 34 to 35 of that same attachment 2 containing the legislative history for the 1999 amendments to the blacklisting statute. The author, W. Anderson Forsyth, writes, one of the tricks or pitfalls that Montana business owners are subject to arises in the wrongful discharge field. Terminated employees can request a letter stating the reasons for their termination from the unsuspecting employer. The letter might reference Montana's blacklisting statute, or it might not, usually not. The letter may be innocent, something like, please tell me why I was fired so that I can advise future prospective employers. The catch, however, is that the Montana Supreme Court in 3 cases has held that once the employer answers the question, whatever the employer states becomes the sum total of the defense an employer can offer if later sued for wrongful discharge under 39-2901. The 3 cases I referred to are Swanson, Galbraith, and Jarvanpah. If an amendment to SB 271 could include the following, it would fix the problem. And he proceeds to propose language which is very similar to what was actually ultimately introduced by Governor Roscoe, but he made specific reference only to the WDEA, not to any other laws that were specifically impacted. As I mentioned earlier, the fact that Bean applied the Galbraith rule to the unemployment insurance context makes it makes more sense that Governor Roscoe would say this applies in any action. We're not going to specifically state which types of action the Galbraith rule does not apply to. We're going to implement this fix, and it's going to apply to all actions and allow employers to present their evidence. The committee minutes continue, and the grammar is a little choppy. But it says Senator Keating asked for the employers who are aware that their statement is their only defense available oftentimes were not responding at all because of fear. Also, it has been stated that there are out-of-state companies who won't do business in Montana because of that. This law will make sure the employer knows he may be looking at a wrongful discharge suit and will therefore express the full extent of the discharge because he realized that's his only defense. The contest between the employer and the employee becomes much fairer under the law. People wanting to do business here are at least getting a fair shake, and it wouldn't be an inhibitor to somebody coming to the state to do business. Again, we're focused on the issue of Galbraith and Jarvenpaugh and the problems that's created. Now, Smith claims on page 2 of his reply brief that the changes were directed only at violations of the blacklisting statute. Based on the legislative history we just reviewed, that clearly is not the case. They're talking about Galbraith, they're talking about Jarvenpaugh, they're talking about wrongful discharge actions in the committee minutes.
But counsel, the legislature didn't get the job done. They didn't get it into the wrongful discharge act.
Well, the language,
It's only in the blacklisting statute.
that's right, it's only in the blacklisting statute because the blacklisting statute is the only place that this rule appears. This rule isn't in the WDEA. This rule from the blacklisting statute was engrafted onto the WDEA by the court in Galbraith. And I mentioned this earlier, the fix therefore makes sense too. If the problem is in the blacklisting statute, let's fix the blacklisting statute. That's exactly what the legislature and Governor Roscoe did. There's no need to amend the WDEA because the WDEA never said anything about the evidence that could be considered.
Well, but Galbraith applied to the WDEA. It was a wrongful discharge action, and that was present when the 1999 amendments were there.
That's
Were
right.
made.
But again, it was based on the blacklisting law. It was based on the blacklisting law as applied in Swanson that Galbraith made the rule, you can't rely on this in a WDEA action. And so again, you fix the root of the problem. There could have been a Band-Aid patch, I suppose, and amend the WDEA, even though the WDEA was never the issue. It was always the blacklisting statute that created this evidentiary hurdle. And Governor Roscoe expressly acknowledged that when the bill hit his desk. He could have signed the bill that came to him. He could have let it sit for 10 days, in which case it became law, or he could have vetoed it, or he could have sent it back with revisions, which is the course of action he took. And in sending it back, he said, with respect to Senate Bill 271's repeal of the section 39-801 MCA, the requirement that an employer provide a written statement of the reasons for discharge, it is the intent of this provision was to address the inability of employers to fully defend themselves if an employer brought a wrongful discharge action. Right? This court's charge is to give effect to legislative intent, and he just told you what the intent was. Literally, he says the intent of this provision was to address the inability of employers to fully defend themselves if an employee brought a wrongful discharge action. I've never seen an expression of legislative intent quite this clear where he says, here's the intent. Let me tell you what we're trying to do here.
So under your interpretation, if we were to agree that the statute applies in any action, whether brought under the blacklisting statute or not, I assume it's still within the district court's discretion to determine in the context of the employee's discharge, whether the employer's reasons are relevant or not relevant to what it told the employee at the time of discharge.
Absolutely, right? Questions of relevancy are always within the discretion of the trial court. And that's why I don't think this rule is necessary either, right? 49 other states don't have the Galbraith rule, and they still manage to figure out what's admissible and inadmissible. And normal rules of impeachment are the proper tool here. if I'm an employer and I terminate an employee and I say it's because of absenteeism, and that employee sues me for the termination, let's say under any state human rights act or Title VII or any other law protecting discharge from employment, if I'm the employee and I can prove I wasn't absent from work, and the employer comes back and says, oh, well, no, it's really because we think you stole money from us. Normal rules of impeachment allow me to say, but look right here, you said on my termination notice that it was absenteeism and I wasn't absent. This is, not the great problem that Smith and the MTLA would have the court believe. Normal rules of relevance and admissible evidence solve this problem without having a concrete rule that frankly only creates more problems than solutions, right? We see the problems because courts are always struggling with, and this court has struggled in, maybe not struggled, has grappled with the issue in Jarvinpaugh and in McConkey, trying to figure out, well, does this substantiate the reason, right? In Jarvinpaugh, it was evidence of morale issues post-separation, and the morale issues improved. In McConkey, it was financial issues caused by McConkey to the electrical co-op that weren't specifically referenced in the termination letter, like a bad debt equity ratio and the need to hire bankruptcy counsel. Again, we've got 3 cases that have gotten it right since 1999. Bordelais v. Semi-Tool was the first in which the court held the 1999 legislature amended 39-801 to state that an employer is not limited to the reasons set forth in response to the employee's request for a written statement of the reasons for discharge and may modify its response at any time. Galbraith no longer applies. Stevenson v. Belko took the lead of an excellent law review article by William L. Corbett, former law professor at the University of Montana School of Law. Mr. Smith describes it as an errant law review article, but it's a 50-page law review article with 250 footnotes, well-researched, well-supported, well-cited. That analysis was incorporated into the Stevenson decision. And USDC Judge Malloy in Erdman v. Walmart stores makes clear the same thing, that those cases relied on a prior version of Montana Code Annotated 39-801 that has been amended, and so holding that it was no longer good law. Again, those cases got it right. To your point, Justice McKinnon, McHugh is about the only case that's gotten it wrong. Obviously, this court didn't address the issue in McConkey, even though that was decided subsequent. With that, I'm out of time, unless the justices have any other questions for me. Well, thank you for your consideration of this matter.
Thank you, Mr. Fitzpatrick. Mr. Hall? I believe you have 10 minutes.
Thank you. Your Honors, the plain language remains. The plain language of these 99 amendments, they are self-contained, they're self-referential, they're clear, they use good, easy to understand language. This is not a complicated statutory scheme under this section. The 1999 amendments are not ambiguous. In fact, in Charter's brief to the Montana Supreme Court in this case, Charter states, Charter submits that the 1999 amendments are not ambiguous, and thus the court need not turn to the legislative history to interpret them. We agree. The amendments are clear. We do not even need to look at the legislative history. However, even if we do, the context of the legislative history and the end result of, again, the plain language of the amendment proves what the legislative intent was and what it was not. Charter has emphasized comments by a state legislator, by Andy Forsyth and by Governor Roscoe. However, if we want to find out the intent of the legislature, this is all we need to look at. Those concerns were not codified. They did not make it into the law. If the legislature intended to interpret this Galbraith rule and these 1999 amendments differently, it could have and would have done so at the time, after McConkey was decided in 2005, or even last year when they made significant amendments to the WDEA, some of which specifically did address case law, like the managerial discretion rule from Buck and other cases. Judge Christensen's McHugh decision is the most persuasive and most compelling decision that has faced this issue, and his reasoning should be followed here. In that case, the employer made the same argument that Charter is now making, that Galbraith and McConkey were abrogated by the 1999 amendments to the anti-blacklisting statute, which is the certified question to this court. Judge Christensen disagreed for two reasons. First, he noted that a number of cases, Jarvis, Flanagan, even our Smith district court cases, have utilized this Galbraith rule outside of the blacklisting context, both before and after the 1999 amendments. So the amendments don't abrogate those cases. And also the amended blacklisting statute didn't apply to the facts of that case, just as they don't apply here because there was not a service letter or a request for a service letter. So there's no reason to disagree with Judge Christensen's well-reasoned decision, and we encourage the court to do so in this case as well. Thank you so much for your consideration and your time.
Thank you, Mr. Holmes. That concludes the oral argument in this case. The court will now take this matter under advisement, and we will issue an order in due course. Once again, I want to thank the State Bar Association, the law school, and students at the law school for their assistance with presenting this argument this morning. We're dismissed.